Thank you very much. I would also, at the outset, like to acknowledge and pay my respects to the First Nations people on whose land we meet today. I pay my deepest respects to their elders past, present and emerging, and to any Indigenous Australians that are joining us today. I would also like to thank Dr. Cameron Rolls for inviting me to present this lecture. It is an enormous honour, and I really appreciate the support of ANU. It is a real delight, and as I say, an honour to be here today to give the annual Phillipa Weeks Lecture. I was not fortunate enough to have met Phillipa in person. My academic journey started after hers ended, but I am very good friends with Shay McChrystal. And part of what I'm going to talk about today is inspired and collaborative work with Shay. And I know Shay held Phillipa in the highest regard, as did many of her colleagues. So in preparation for tonight's lecture, I went back and looked at some of the published pieces that came out after Phillipa's passing, and I was so struck by the widespread admiration that Phillipa generated amongst her colleagues, her students, her friends, her family, not just for the excellence of her scholarship, but for her generosity and warmth as a person. She has served as an inspiration for me tonight, but also I think as a broader inspiration. She's the kind of academic I would like to be. So I hope this speech will do her memory justice. Okay, so as you might see from the title, I quite like alliteration. And when Cameron extended the invitation to give this speech, he indicated that I could choose any labour law topic that I would like. With so much happening in the space right now, why then choose collective bargaining in franchise networks? It seems a little niche. Besides the fact that it formed part of an extensive DECRA research program, I also believe that looking at and analysing bargaining norms and processes in the context of franchising is both important and revealing. It's important because we're currently in a cost of living crisis, and everyone is trying to figure out what to do about that. Is it inflation? Is it wages? Is it both? How do we redress the rising inequality in our society? It's also revealing from a conceptual point of view because franchising is an archetype of what's known as fissured work. So similar to other fragmented work arrangements like labour hire or gig work, franchising exposes the boundaries and weaknesses of traditional labour law concepts, which are predominantly premised on a binary employment relationship being in existence. And in recent decades, we've seen the institutional pillars underpinning this normative model of employment break down due to the corrosion of the vertically integrated firm and the accompanying rise of what's known as multi-party networks. Engaging labour through these networks is a fairly neat way to directly reduce labour costs. This strategy allows firms to avoid unionisation and weaken worker power. It also allows firms to avoid accompanying benefits that flow from collective bargaining. It means that many firms can sidestep on costs such as superannuation and workers' compensation and other risks associated with direct employment. In the words of David Weil, who was the person who first coined the term fissuring, he says it allows lead businesses like franchisors to solve the pay problem by transforming their wage determination woes into a conventional pricing problem. You create a market, they fight for contracts, you lower your expenses and profit margins expand. So in Australia, one response to this problem has been a desire to reinvigorate collective bargaining in relation to work relationships. Multi-employer bargaining is one of the most contested features of the Albanese industrial relations reform. It sparked enormous debate in the lead up to Christmas last year. But those industrial relations reforms are significant in that they extend the existing agreement-making mechanisms in two significant ways. So the Secure Jobs Better Pay Act, which was introduced in December 2022 and had sort of some lagging effects in terms of when things came into operation, it explicitly encourages and envisages enterprise agreements to apply beyond the boundaries of the firm. This is fairly radical in a sense because bargaining norms are traditionally premised on the idea that bargaining takes place between an employer and an employee. It doesn't go beyond that employment relationship. The second important reform that's proposed is under the auspices of the Closing Loopholes Bill, which proposes to facilitate collective bargaining in relation to what they term employee-like workers, which is defined or confined to road transport workers and digital platform workers that are characterised as independent contractors at common law. Independent contractors have traditionally been locked out of accessing bargaining frameworks that are available under the labour law system. But in order to evaluate these most recent reforms, what I'm going to attempt to do today is take a step back and look at the way in which bargaining has taken place under the pre-existing bargaining regime in the context of franchise networks. And franchise networks and their regulation is distinctive in multiple ways, which I will detail. I'll also look at what is happening in the competition law space, because in parallel to all these developments that is happening in the labour law domain, there have been some really important and novel experiments under the Competition and Consumer Act, including the introduction of a class exemption for small business collective bargaining. While these bargaining frameworks have emerged under distinctive legal regimes, in my view, the reforms are largely driven by a common ambition, a common goal, and that is to redress power imbalances and curb exploitative behaviour. And it's my research more extensively in the franchising space suggests that it is power, and particularly the power that exists between franchisors and franchisees, which should be at the heart of any attempt to improve and sustain decent work for franchise workers. As you may have already picked up from that very lengthy introduction, this is not a straightforward exercise, and part of the reason why it's complex and part of the reason why I find it interesting but also challenging is that franchising sits at the intersection of labour law and competition law. What's so special about franchising? I think franchising is very special in many different ways. It remains unique and it's unusual. It's been described in various forums as a parent-child relationship. I've got 3 children. It's a love-hate kind of relationship at times. A marriage, again, or a quasi-employment relationship. In all of those 3 relationships, there is potential for economic dependence and power disparities, and I think that is true also of franchising. Franchising, there's many definitions of franchising. They are not consistent, even in the Australian statutes that deal with franchising. So I'm going to just introduce a kind of common definition of franchising, which really recognises that it's a contractual relationship which has this distinctive feature, and that is the franchisor's right to exercise significant power over the franchisee. But in return, franchisees expect significant assistance from the franchisor. And I think that this seemingly simple division of responsibilities between the franchisor and the franchisee belies the reality of many franchising relationships, which has been described as fraught with power struggles, conflict escalation, and communication difficulties. Again, somewhat like a marriage. Indeed, what's interesting too when we think about franchising as compared to other types of business relationships, cooperatives and mutual entities are excluded from the definition of franchising in large part because those organisations do not exhibit the same inherent power imbalances and potential conflicts of interest. So the concentration of power in the franchisor is produced and reinforced by a range of laws relating to contract, property, corporations and competition. The franchise agreement is at the heart, as I say, of any franchising relationship. It is ordinarily prepared by the franchisor and it is ordinarily in standard form. It lays the foundation for the franchising relationship over the longer term. They're one-sided and they are designed to privilege the interests of the franchisor. Conversely, the franchisee is required to comply with an overwhelming number of commitments. So the franchisor reserves much discretion, particularly discretion over things that are valuable, such as IP and strategic decisions about how to run the franchise. Conversely, the franchisee is required to comply with a whole range of obligations that are imposed by the franchisor in relation to leases, in relation to store layouts, in relation to pricing. Many vertical restraints are imposed by the franchisor. And that relationship breeds vulnerability and exploitation. It produces franchisor opportunism and is one of the reasons why we have franchise-specific regulation in Australia and in many other jurisdictions. In Australia, we have the Franchising Code of Conduct, which is currently under review because it's not doing its job, as well as protections under the ACL, so some of those broader commercial protections like prohibitions against misleading or deceptive conduct or prohibitions against unconscionable conduct. While those franchise-specific protections are important, they are predominantly derived from contract law principles, and I think that they are deficient because they don't address what is critical for a healthy franchising relationship, and that is to address fundamental values such as fairness. They can also leave third parties in the economic relationship unprotected, and there I'm thinking most of employees and their representatives. So the franchising relationship is often described as a paradox. They operate legally distinct businesses. It's meant to be part of a win-win arrangement, and yet there's often this misalignment of goals. They have divergent priorities and perspectives. There is a paradoxical demand within a franchising relationship to simultaneously act in your own interest, act in the interests of the counterparty, and act in the interests of the network as a whole. So Hugh Collins has indicated that he doesn't believe existing legal concepts map onto and reflect the network features that are present in a franchising system. One constant tension that comes through from these kind of conflicting priorities, and one that strains the franchising relationship, is the franchisor's desire for standardisation and uniformity. It's all part of being a franchise, is protecting the brand, and that is about system integrity. And on the other hand, the franchisee who goes into franchising think they're going to be their own boss, their quest for independence and autonomy. And these tensions between what the franchisor is seeking and what the franchisee is seeking is manifest in bargaining patterns and approaches. So I've taken this quote from Jenny Buchan and Gihan Gonaskara, who recognise that there are these power dynamics that are still problematic despite everything that has been generated in the regulatory space for some time. It's seen as the Achilles heel of the franchise model. Their kind of suggestion that we need to think more carefully about unconscionable conduct and good faith, my response is we need to think more carefully about how collective bargaining can be harnessed to respond to these paradoxes and tensions. And Teubner suggests that one of the issues that we have in franchising arrangements is the way in which they exploit contract and corporations law to collectivise action. But they collectivise action without simultaneously collectivising responsibility. So what we see in practice is that franchisors might not actually exercise direct control over frontline workers. They are not necessarily handing over the employment contract, but they reserve immense levels of control over the working conditions by retaining the discretion and capacity to issue instructions to intermediaries, which are the franchisees or franchisee managers. So they control everything else except wages. They control everything else except employment. But by doing that, they effectively control conditions. And they use both coercive and direct and non-coercive and indirect forms of power. This might include the use of monetary rewards and sanctions, the promise of a renewal of a lease, for example. They are harnessed by the franchisor to cultivate and sustain control over the franchisee. So in labour law, collective bargaining is a familiar mechanism for redressing power imbalances, but it's less familiar in the commercial realm, and that's partly because it's generally seen as a form of anti-competitive conduct. So when I'm looking at collective bargaining, I'm thinking about how collective bargaining can and should be reconceptualised in order to make effective headway in franchise networks. I argue that franchisee employees cannot rely simply on collective bargaining with the franchisee alone to improve working conditions, because it's franchisors that effectively set the terms of employment. They are the ones with the meaningful profit margins that can be redistributed. They have the resources to develop a sophisticated IR strategy and seek legal advice. They have the influence over franchisees that can be deployed to derail organising efforts. And we see this in the US in particular in response to the Fight for 15 movement. So the McDonald's franchisor harnessed all its resources to try and resist that movement for higher pay and better working conditions. So Elmore and Griffith suggest that if we're looking at collective bargaining in this space, franchisors are the linchpin. We can't have the conversation without incorporating franchisors. So now I'm going to turn to, well, to what extent are franchisors already involved in bargaining in Australia? And this is where I've been looking at different models of business format franchising and different ways in which bargaining attaches to those models. So when we think of bargaining in franchising, when we think of franchising generally, we flick to, I was going to say, if anyone's seen the Barbie movie, which is McDonald's. And we flick to the McDonald's model where franchisees are employing armies of young workers. McDonald's in Australia, biggest employer of young people, over 100,000, 80% under the age of 21. Some franchises do fit within that typical franchise paradigm, but others do not. And I just wanted to kind of touch on some of the kind of diverse forms and structures that we see. Franchise systems, of course, cross many, many different sectors: physiotherapy, pool maintenance, Pilates. So it's not confined to fast food, but most of the bargaining is taking place in fast food, and I'll explain why that's the case. So this is the kind of stereotypical franchise, a franchisor duplicating or licensing its business and the business format to a single unit, independently owned franchisee. Sometimes you've got more sophisticated franchisees, a multi-unit franchisee. They might have 15 stores that are operating. They might have 150 employees. So these assumptions that franchisees are always unsophisticated or first-time business owners doesn't quite gel when you're looking at multi-unit franchisees that might be owned by private equity, for example. And then you've got company-owned franchisees. So these are owned by the franchisor, and so they also have kind of a stronger alignment, of course, to the franchisor's interests, but you've still got the franchisee manager that can play a role. So that type of bargaining, particularly when you're focusing on the improvement of working conditions of franchisee employees, that is predominantly governed by the Fair Work Act. But here is my first, what I've termed my regulatory fault line, and that is that we also have at the same time bargaining taking place in the Competition and Consumer Network. We still have these types of franchises, the same types of franchises falling within the Competition and Consumer Act. The difference here is the focus of bargaining is on the franchising relationship itself. So it is not about the bargaining outcomes for a third party such as a union or an employee. And the other important difference here is that it also encompasses self-employed franchisees. So these are franchisees that employ no one else. They are independent contractors. These are very common in cleaning and home services, so gyms, mowing and other types of franchising. I say it's a fault line, but it's not a clear-cut boundary, because what happens in this space in terms of redistribution of the power that's inherent in that relationship will influence ultimately, as I say, what happens in the labour law space. It has flow-on effects for workers in relation to their direct employer. Because, of course, if franchisees as a group can push back against the business model of the franchisor, they hopefully will be in a better financial position. That hopefully means that they are better placed to enhance working conditions and to comply with minimum standards. And that's something that's come through in a number of the high-profile cases that I'll get to. So standard setting in franchising has always been distinctive, and I've already mentioned the fact that junior rates are a really important feature of the fast food industry in particular. It's a critical underpinning of the business model in the quick service restaurant sector. Since the Fair Work Act came into force in 2010, different bargaining practices and patterns have emerged. And in this section, I'm going to focus, as I say, on the behaviour prior to the Secure Jobs Better Pay Act, which came largely into effect in June 2023 in relation to bargaining. But these have not yet been used by franchising parties. So we're sort of like predicting what might happen in that space. And I'm using what's happened previously to think about and hypothesise what might be the potential and the pitfalls in that regard. So it's quite complicated, and I appreciate that there's lots of non-labour lawyers in the room. So I'm going to try and keep it at a fairly shallow level of analysis. What's interesting here is there is actually a multi-employer stream that was in existence under the pre-SJP, the pre-Secure Jobs Better Pay Act, but it wasn't readily utilised by franchisors and franchisees. Instead, they were using other types of bargaining channels to strike collective bargaining agreements. The system of agreement making in the Fair Work Act is premised on two interrelated concepts, that is the employer and the enterprise, but somewhat confusingly they've been defined in counterintuitive ways. So an employer can include one or more employers, and an enterprise can include multiple kind of projects, undertakings and businesses. So they're defined very broadly. So first of all, with respect to the single employer agreement, this is a kind of the straightforward, typical agreement made between a single employer which covers their employees only. This model has been adopted in the grilled franchise, which is like the Healthy Burger franchise. What is interesting about the agreements that have been struck by grilled is that they've made 32 agreements, all the same, right? So it's 32 agreements, very little evidence that there's any negotiation or bargaining. It appears that the franchisor produced a template agreement and then just sent it to all their franchisees and said, yep, go ahead and get it approved by the Commission. But it's sort of confusing as to why you would do that, because it's resource intensive in a sense, and it's not entirely clear why Grilled adopted this approach, but Grilled is very sophisticated when it comes to using different systems, traineeships and other things to their advantage, and I think this is true also of the agreement making system. So one possible reason is that it gives Grilled an industrial advantage. So what they're effectively engaging in is pattern bargaining, but they don't have the same nominal expiry date. They all expire at different times. Again, that's quite helpful for Grilled because on the one hand, having duplicate agreements across their brand is in their interest because it ensures uniformity, so it sort of speaks to that broader concern of franchisors. But at the same time, by having different nominal expiry dates, there's really there's very little risk of industrial action anyway, but this completely blows it apart. The idea that there could be organised industrial action across the network, it's very difficult to do in the context of these agreements. The other important feature, I think, of this agreement-making model, particularly as we get to the last few years where there's been a real backlash against what's called zombie agreements, is that if one grilled enterprise agreement is terminated, the others still stand. You have to terminate them all individually. That makes it much more difficult, again, for unions, workers and others to get back on the award, which may provide better terms and conditions. And, by providing greater stability to the underpinning business model, it allows the franchisors and the franchisees to keep costs down. So that's all, again, part of the broader franchising narrative. The second model, which is a single interest employer with a common enterprise, again, this was traditionally utilised by franchising systems, particularly some of the major established brands like Yum restaurants, so they had KFC and previously Pizza Hut. In 2010, so shortly after the Fair Work Act came into effect, the Commission handed down a decision which suggested that the KFC franchises were a common enterprise and an agreement of this type could be made. They said KFC outlets are not isolated standalone businesses. They are operated under franchise agreements which require a very high level of standardisation and cooperation. Most features of the business are standardised and operated under the KFC umbrella. Profit is effectively shared as KFC obtains a proportion of revenue from franchisees. What I found interesting about this observation is that it recognises the contractual connection between the franchisor and the franchisee. In a sense, it recognises, in some ways, the paradoxes, but it fails to take into account the way in which these interests can diverge. It also fails to take into account the way in which profits are shared in a franchise, because it makes it sound very altruistic, where I don't think that's necessarily the case. And I think this is also relevant when we look at some of the cases involving 7-Eleven, which obviously was made famous in 2015 for engaging in systemic wage theft. When that then spurned a whole number of cases brought by the Fair Work Ombudsman, some of the franchisees sought to defend their behaviour by saying that it wasn't their fault, it was the fault of the business model imposed on them by the franchisor. Those arguments were largely dismissed by the court. they said, well, you're the direct employer, so it's your responsibility to comply. Although there was some recognition that the previous model did place significant restrictions on the capacity of franchisees to generate an income from the operation of the franchise. So there was some recognition that this franchising relationship had these really adverse implications. These questions are especially relevant in relation to Baker's Delight. So Baker's Delight takes a slightly different approach in terms of it has agreements where it sought a prior authorisation from the Fair Work Commission, but to a large extent they are very similar in effect. Baker's Delight is currently facing enforcement litigation. It's a test case of the provisions that were introduced in 2017, which effectively extended secondary liability to franchisors for underpayment contraventions committed by franchisees. Because I really want a decision. I really want to know what the court thinks and says about these issues, about the way the franchising relationship is set up, the business model. To what extent can that be taken into account in determining the liability of the franchisor? The franchisor can raise a defence. It can show that even though it knew or ought to have known that the contraventions have taken place, it took all reasonable steps to prevent those contraventions. And then there's a series of factors that the court can take into account. But what I want to know is, will the court take into account these sort of broader, more amorphous kind of factors, which are, in my view, some of the most relevant factors, but don't necessarily come through expressly in the relevant provisions. Okay, so what are some of the barriers? So that's kind of the kind of technical overview, but I want to go let's get into the nitty gritty. Like, what were the problems that came through? So I interviewed a number of stakeholders from across the franchising, in labour law, in competition law, those who've had experience with franchising. And on the one hand, you go, well, look, this is amazing. Under the pre-existing Fair Work Act, we actually had agreements that were spanning or crossing across the kind of the sanctity of the corporation. We had them going across firm boundaries in a way that you don't see often in other jurisdictions or in other types of business models. But when you dug a little deeper, there were some really concerning trends that emerged. The first is the zombie agreements, which I mentioned before. So they have gone on for so long. So these are agreements that were made under the work choices provisions made prior to 1 January 2010. And some of those zombie agreements are still in operation. So they're frozen in time. And that means that people who are working under those zombie agreements are getting paid far, far below the relevant award conditions, because those zombie agreements cut out penalty rates, they cut out casual loadings, they cut out a range of protections that we take for granted in the Australian system, which is meant to have the safety net of awards. And so one of the things I wanted to just touch on was not only the fact that it reduces pay for some of the lowest paid workers in Australia. There were also concerns that these zombie agreements that were just floating around were really difficult to enforce. So if you had a worker who came in and said, I'm being paid $10 an hour, and I think I'm being paid under a 2009 enterprise agreement, those who were trying to help them enforce their rights would have to find that agreement. That's the first challenge, because a lot of these enterprise agreements, particularly if they're made by independent franchisees, don't mention the brand. So the franchise worker's like, I'm a Subway worker. And they're like, well, who's your employer? They're like, I don't know, Subway. And obviously that's not a corporate entity. That's not their corporate employer. So trying to find the agreement's the first challenge. Once they found the agreement, they then had to work through, okay, you're under that agreement. Now we have to look at all the transitional provisions and figure out how this applies in your particular circumstance. So it's very, very complicated. It makes it very complex and resource intensive. So as I mentioned before, what's interesting now is that we've got this, in the last few years, a wave of termination applications. So in the early days of the Fair Work Act, everyone was very enthused about making enterprise agreements. They're like, it's a Labor-friendly piece of legislation, let's get going, let's make agreements. 10 years on, we see the opposite trend. We see lots of unions and worker representatives applying to have these agreements terminated because, in their view, they were disadvantageous as compared to the award. But as I mentioned before, the approach that franchisers took in the first place to how they made the enterprise agreements, whether they made 32 separate enterprise agreements or one centralised enterprise agreement that covered the network, then affects how difficult it is to unwind those agreements. So if there's lots of terminations, and a number of people said, so this is one of the big challenges, I think, when there's a separation of that type. If the bargaining was centralised from the outset, then that process is far more straightforward. This is in some ways an artefact in a sense, because the Secure Jobs Better Pay Act put in a sunset provision finally for zombie agreements. So they're all going to come to an end on 6th of December 2023, so a few more weeks, unless the Commission extends it, which, you know, you'd have to hope that there would be very limited circumstances in which they would be extended. As I've already mentioned, very little evidence of any kind of genuine or real bargaining, lots of template agreements being used. There are some important representation rights included in the Fair Work Act, but it became very evident very quickly there's some major deficiencies. So a number of worker representatives were like, we didn't even know that a franchise was applying for a single interest employer authorisation. We did not know that they planned to make an enterprise agreement that covered most of their franchisees in New South Wales, for example. We kind of found out after the event. And, you know, that's a real problem, because then they can't inform, assist, organise. It makes their job very much harder. So I mentioned before my friend Shay McChrystal. She's recently published a piece with Anthony Forsyth on the Secure Job Better Pay amendments, and in that article they talk about the fact that, and you know, in a lot of other research as well, one of the real problems for agreement making under the Fair Work Act, it is a model which is employer controlled and privileges non-union agreements. And the idea around that was sort of to democratise agreement making, to allow anyone to appoint a bargaining representative, union or non-union, and then they could go ahead and make an agreement. But it has had really significant negative effects. For example, it's enabled some employers, particularly where union density is low or the unions might be light touch, to obtain the benefits of avoiding otherwise applicable award conditions with only the barest of trade-offs. So 1% pay increase to the base rate of pay, and you get free pizza or something of that type. And once these agreements are in place, of course, then workers are locked out from bargaining for better conditions for up to 4 years. It also sets a low base for future negotiations, so it has this kind of legacy effect. This is particularly concerning, I think, when you take into account the characteristics of the workforce that are present in the fast food sector. So in 2018, a Commission member who was looking at an agreement relating to the Guzman and Gomez franchise, so Mexicana, they raised concerns about the apparent absence of an employee bargaining representative and the lack of any evidence to suggest that bargaining was going on. And they were particularly concerned because 2/3 of the workforce were from a non-English speaking background, almost half the employees were engaged as casuals, and around 1/3 were aged under 21. So how do they vote on that agreement without any kind of independent person or any independent support to assist them in understanding what they're trading off in entering into that type of agreement? And I think this captures some of the issues that were coming through in the interviews, and a kind of explanation as to why unions weren't present, and that is because of the nature of the franchising system itself. And that is, franchising is an archetype of fissured work because it splinters the organisation. So you once had one large firm, now you've got many smaller firms. So they're all tiny businesses that are doing it, where there's no involvement in unions. You've also got that combined with a workforce that is inherently insecure, and there's high rates of turnover. So this is a real challenge, and not one that I think is easily overcome, to be honest, in terms of organising. And then this was another one when I asked about industrial action. They were like, it ain't going to happen. It ain't going to happen. You can't get a ballot. You're not able to take action. Even if you organise one store, no one else is going to do it. So it's really, really problematic in terms of trying to think about how you can support meaningful collective bargaining when you don't have access to the tools that ordinarily allow for coercion or compulsion. Another real issue that was evident was lax application of what's known as the boot, which is the better off overall test. This is a requirement of agreement making that any agreement, in order to be approved by the Commission, the Fair Work Commission must be satisfied that at the test time, an employee to be covered by the enterprise agreement would be better off overall if the agreement applied than if the relevant modern award applied to that employee. And so there was evidence both in retail and also in franchising that there were a number of enterprise agreements that, as I said, had very, very limited benefits and were ultimately found to have not necessarily passed the boot. Since the boot's been tightened up, so there's some really important cases in 2016, there's been a lot more scrutiny of the enterprise agreements that are being put up for approval, particularly if a bargaining representative isn't present, and the test has been tightened up. But the consequence of tightening up the test is that now we have franchisors who aren't interested in bargaining, right? Because they were using agreements to effectively evade that safety net, or manipulate the safety net to their advantage. Now that sort of window of opportunity is closed, that the boot test has been applied more rigorously, there is a real problem that they face in terms of trying to use the agreement making system to reduce labour costs, which is what effectively they were doing. They would say it was promoting productivity, they would say it was getting out of complex and unnecessary award conditions, but at the end of the day, a lot of it seemed to be about that bottom line. I'm just going to quickly cross the regulatory fault line that I mentioned before and talk about collective bargaining under the Competition Act. As I said, there was a blanket prohibition on collective action amongst independent contractors. It is seen as a form of anti-competitive conduct. There were kind of these anachronistic provisions that allowed for some collective bargaining through the notification authorisation provisions of the Competition and Consumer Act. They weren't used very much. And so in 2021, the ACCC introduced a class exemption for collective bargaining by small business. This applies to three classes of business. Most relevantly, it applies to franchisees seeking to collectively bargain with their franchisor. It's a kind of straightforward process in a sense, in that in order to access the exemption, in order to gain immunity from the prospect of liability under the Competition and Consumer Act, eligible businesses must simply file a notice with the ACCC. There's no application fee, and then you're good to go. basically. There's very few restrictions on the scope, the level and the content of bargaining. Very, very different to what we see in the labour law space, where every move has multiple provisions attached to it. But I think that's somewhat misleading, because even though, in a sense, parties are left to fill in the details, there's very little structures or supports to provide for meaningful bargaining. There's no ability to engage in anything but voluntary and consensual bargaining. So if you've got a reluctant bargaining target, there's no way to bring them to the table. The legal status of any ultimate agreement is unclear. Presumably it's just enforced via contract or commercial law. There's actually kind of big questions, I think, around enforceability and privity when you've got group agreements such as this. And there's no protection against retaliatory conduct by the bargaining target against the franchisee that's seeking to advocate on behalf of the group. So it was introduced in 2021. We've now seen 70 notices lodged. Only 5 have been with business format franchise. I was a little bit disappointed with that, to be honest. I was like, come on, I'm about to do a whole speech on this. Only 5. Once we exclude motor vehicle dealerships. But I still found even that 5 was still kind of interesting in terms of how they identified the target, how they identified themselves. Like, were they represented by a franchise association or not? Only 1 was represented by a formal association. Very different, again, to the kind of patterns we see in the labour law space to some extent. The subject of bargaining, some of them were like, we want to bargain about all the breaches of the franchising code. I'm like, I'm not sure that's within the scope of the bar. I think someone I mentioned that to said, I think they need to sue. And I was like, I think you're right. I don't think you're going to engage the franchisor in voluntary bargaining over how they breached their legal obligations. But others were more confined. So others were about input prices or selling prices. So things that you would expect to be the subject of some negotiation, and go to those concerns I mentioned earlier about trying to reinsert notions of fairness into the franchising relationship. So even though I was quite hopeful about the potential of bargaining, when I spoke to interviewees, they were really cynical. They were like, it's of marginal value. There was like, they're not going to do anything. And I think, you know, the concerns I've just raised were also coming through in the interviews. There was like this interviewee who said, you know, what are they going to do when they get together if they don't have strike action? Like, how do they bring a reluctant target to the table? The absence of any protection or support for the franchisee was also identified as a weakness. But what was interesting, so I always think about kind of sort of adverse action or retaliatory action. Franchises are often more sophisticated in a sense, and it goes back to what I said earlier about the way they use coercive and non-coercive power. So this interviewee said what he'd witnessed was that when there was a group of franchisees that were getting quite vocal and agitating for change, the franchisor would buy out the loud one. Right? So they would identify who are the leaders here, and they would say, how about we resolve this dispute, buy out your franchise at an inflated price, and you sign this confidentiality agreement. And that, according to the interviewee, said once the franchisor has picked off a couple, the group's disintegrated, it squashes the idea of it being a way to go forward. So I think that in itself is really, really problematic. I think it's also significant that there are no notices, I mean there's only 5, but there's no notices lodged by self-employed franchisees when we know that they are, you know, subject to some of the most exploitative conditions, and they themselves are really providing their labour much like a gig worker, right? So we've got these new shiny protections under the Closing Loopholes Bill for gig workers and owner-drivers. There's very similar kind of issues arising with respect to self-employed franchisees in the cleaning sector, and yet they're excluded from those protections in the Closing Loopholes Bill. So this was, again, a less hopeful kind of reflection by one of the interviewees, and I think that it does present a real challenge. You know, on the one hand, we say bargaining is important to redress power imbalance, but then I was like, what do I say? Where do we go from here? What do we do? How do we address these, I think, fundamental problems that plague collective bargaining both in the labour law space and in the competition law space? I had some kind of modest ideas and then some more significant, sort of broader suggestions. One idea that came through the interviews actually was trying to better integrate worker representatives at critical points in time. So even though worker representatives might not be able to go out and organise industrial action, if they could be alerted to certain things that were happening, whether it was an agreement was going out to vote, an agreement, a special single employer interest authorisation had been lodged, if they were alerted every time those things happened, that would allow them greater opportunity to insert themselves into the process. Improved transparency of agreements. As I mentioned, it's very, very difficult to actually find agreements, particularly when the brand's not mentioned and you've got young workers who don't pay any attention or don't know, aren't issued pay slips or whatever. They don't have any idea who their employer is. So there should be a national register of agreements that's easily searchable, possibly along brand lines. And this is also true in the competition space where there's no register of any agreement. So you have no idea whether or not there is agreement that's been concluded by a self-employed franchisee group. I think there needs to be enhanced bargaining supports and structures. Shay, McChrystal and Nancy Forsyth have obviously pushed very hard for industrial action. I agree on a kind of conceptual level, but I'm also a little bit concerned on a practical level once I've had these interviews with various people on the ground about how you would actually make that happen when it's so difficult to organise such a transient workforce. So my more modest kind of suggestion was, well, let's at least protect people who are engaged in bargaining from retaliatory conduct or adverse action, including the kind of things I mentioned before about where there's sort of buyouts in a way that fractures the group. And I think we also need to have and continue the conversation where we try and bridge these regulatory fault lines, where we try and ensure that we're not confining ourselves to just thinking about bargaining in a particular legal domain. That's all I wanted to say, so thank you very much.